I inherited 20 acres of quiet, family land. I thought it was my future. I was wrong. I woke up one morning to the sound of bulldozers, not on the horizon, but right outside my window. They had already paved roads I never approved, and were framing houses on a grid that wasn't theirs to build. My peaceful field was gone, replaced by the skeleton of a suburb I never wanted. They never made an offer. They never sent a letter. They just took it. I was just one person, standing against a multi-million-dollar development company and their team of lawyers. They thought I would roll over. They thought I was powerless. But they made one fatal miscalculation. I knew a secret about the land they had already stolen. The heart of my world was a 20-acre parcel of land I inherited from my grandfather. It wasn't just property. It was a living scrapbook. Every oak tree had a story. This one was where he taught me to whittle. That meadow was where we'd have family picnics. It was my sanctuary. A quiet, untouched piece of the world just outside the city limits, where the only sounds were the wind in the grass and the distant hum of a tractor. I lived in the old farmhouse my grandparents built, a cozy, slightly creaky home filled with memories. My life was simple and predictable, and I liked it that way. I had a good job in town, friends who would visit on weekends, and this deep, abiding connection to my family's legacy. This land was my anchor, the one constant in a changing world. I was its guardian, and it was my peace. That peace, however, was about to be rezoned. I started noticing surveyor stakes with bright pink ribbons at the edge of the property. I'd shrug it off, thinking it was just the county updating maps. Then, a sleek, official-looking letter arrived from a company called Pinnacle Developments. They expressed keen interest in my land, calling it a prime location for progressive community living. I tossed it in the recycling bin. My answer wasn't just no. It was a laughable, non-negotiable never. You see, I made a crucial mistake that so many people make. I assumed that my no was the final word. I believed that the legacy my grandfather poured his life into was untouchable, protected by something as simple as a deed and my own resolve. I didn't know I was already on a collision course with an entity that saw my heritage not as a treasure, but as a spreadsheet cell. They weren't just making an offer. They were drawing a battle line, and I was blissfully unaware that the war had already begun. My refusal to sell wasn't met with negotiation. It was met with silence. For a few weeks, the land was quiet again. I mistook that silence for surrender. I was wrong. It was the calm before the storm. The first official volley came not from a bulldozer, but from a certified letter. It was from the county clerk's office. Dry and bureaucratic. It stated that a zoning variance and land consolidation request had been filed by Pinnacle Developments for the northwestern quadrant of Township 7, which included my property. My blood ran cold. They were trying to have the government reclassify my land, folding it into their massive project without my consent. I fought back. I spent days at the County Planning Commission, arguing before disinterested officials about property rights. I was just one frantic voice against Pinnacle's team of smooth-talking lawyers with polished binders and economic impact reports. They painted me as a sentimental obstructionist standing in the way of progress and jobs, and we lost. The variance was approved, but that was just the beginning. The very next day, the bulldozers arrived, stood at the edge of my property, my heart hammering against my ribs, and watched them tear up the wildflower meadow where my grandmother had kept her beehives. I screamed at the foreman, waving my deed. He just shrugged, pointing to a document from Pinnacle. It was a work order citing the new zoning approval. "It's legal, ma'am," he said, not unkindly, which somehow made it worse. They weren't sneaking around. They were operating in broad daylight, hiding behind permits I couldn't understand. Felt a profound, gut-wrenching helplessness. I was being erased from my own life, one scoop of dirt at a time. I hired a lawyer, my first, but not my last. He was a local guy, earnest and affordable. He sent a cease and desist letter. Pinnacle's response was a 50-page motion to dismiss, so laden with legal jargon it might as well have been written in another language. My lawyer was outgunned. He advised me to settle, to take whatever money they were offering. "You can't fight a machine like this," he told me, his voice heavy with pity. That's when I knew I had to become a machine myself. I mortgaged the farmhouse to its ceiling. I drained my savings, my retirement fund. I was all in, betting my entire future on a fight I was losing. I found a new firm, a boutique practice from the city that specialized in property law warfare. They were expensive, ruthless, and they saw Pinnacle's maneuver for what it was, a brazen land grab. We filed a lawsuit for trespass, conversion, and intentional infliction of emotional distress. It was a Hail Mary, designed to slow them down. It did the opposite. It ignited them. Now, the harassment became personal. They filed countersuits lawsuits against me for abuse of process and frivolous litigation, claiming I was damaging their business. The construction, now protected by a web of legal filings, accelerated. Every day was a fresh hell. I'd wake up to the sound of heavy machinery, the dust from their work coating my windows, my car, my lungs. They cut down the ancient oak tree my grandfather had planted when my father was born, claiming it was in the path of a planned sewer line. It was a message carved into the earth. Your history means nothing to us. The psychological warfare was relentless. I'd get anonymous calls in the middle of the night. My mail was tampered with. One morning, I found a survey stake driven directly through the middle of my grandmother's rose garden. I was living in a war zone, and the enemy was building a suburb on top of me. The foundation was poured. The frames went up. The development, a grotesque parody of a neighborhood, was sprouting like a poisonous fungus. They named it Heritage Oaks, a final, cruel twist of the knife. I was at my lowest point, sitting in my lawyer's office, watching him explain how Pinnacle was now petitioning the court for a quiet title action, a legal maneuver that could, in theory, erase my ownership from the record entirely if they could prove some flaw in my grandfather's deed from decades ago. They were trying to legally vanish me. The despair was a physical weight, crushing me into my chair. I had given everything, my money, my peace, my sanity, and I was still losing. It was then, in that moment of absolute defeat, that my new lawyer, a sharp woman named Sarah who never seemed to flinch, slid a single, faded piece of paper across the table. "We've been so focused on fighting what they're doing," she said, a slow smile spreading across her face, "that we never stopped to look at how they were doing it. I think they made a mistake, a very, very big one." She pointed to a line in a decades-old land covenant I'd never known existed. It was a clause my grandfather had signed, a piece of paper everyone, including me, had forgotten, and it changed everything. The courtroom felt more like a tomb than a place of justice. For over a year, my life had been measured in legal filings and the relentless sound of construction. The house I grew up in was now shadowed by two-story colonials, their blank windows staring down at me like judgmental eyes. I was a ghost in my own home. Pinnacle Developments had filed their quiet title action, and this was the hearing that could decide everything. Their lead lawyer, a man named Mr. Thorne with a suit that cost more than my truck, oozed condescending confidence. He presented their case like a professor lecturing a slow child. He showed maps, land surveys, and copies of my grandfather's original deed, pointing to what he called a fatal ambiguity in the metes and bounds description, a clerical error from 1952. "Your Honor," Thorne said, his voice smooth as oil, "while we sympathize with Ms. Evans' sentimental attachment, the law deals in facts. The property description is flawed. Combined with the zoning variance and the significant public interest in this development, we believe the quiet title action is not just warranted, but necessary for the economic health of this community." My lawyer, Sarah, had been quiet, letting him hang himself with his own rope. When she stood, she didn't approach the bench with aggression, but with a calm, almost pitying demeanor. "Mr. Thorne is correct, Your Honor," she began, and my heart plummeted. "The law does deal in facts, and he has presented many of them, but he has conveniently ignored the most important one." She lifted a single, faded, typewritten page from her folder. It was brittle with age, the paper the color of weak tea. "This," she said, her voice clear and resonant in the silent room, "is a restrictive covenant filed by my client's grandfather, Alastair Evans, with the county recorder on October 17, 1961. It applies specifically and solely to this parcel of land." Thorne waved a dismissive hand. "This is irrelevant. A restrictive covenant might govern home colors or fence heights. It doesn't negate a faulty deed." "Oh, it's relevant," Sarah said, a sharp edge entering her voice. "Because this isn't a covenant about aesthetics. It's a covenant of bloodline inheritance." She turned to the judge. "Your Honor, Alastair Evans was a man who believed land was legacy. This covenant stipulates, in legally binding language, that the title to this land cannot be severed, sold, or in any way transferred to any corporate entity, developer, or trust. It can only be passed down through direct bloodline inheritance, or, in the absence of an heir, it reverts to the state as a protected natural reserve. It was his way of ensuring his land would never be carved up by a developer." The heir left the room. Thorne's smug expression didn't just fade, it shattered. "But that's unenforceable," he sputtered, his composure cracking. "On the contrary," Sarah countered, placing a thick law book on the clerk's desk, open to a highlighted passage. "The Supreme Court of this state upheld the validity of precisely this type of familial covenant in Henderson v. Blackwood, 1978. It is not only enforceable, it is the foundational law of this land, superseding any subsequent zoning variance or corporate claim. She then turned her gaze back to Thorn, and her next words were delivered with the force of a sledgehammer. Which means, Your Honor, that Pinnacle Development's zoning variance is void. Their construction is not merely trespass. It is a permanent, irreversible act of destruction on a legally protected heirloom property. Every house they have built, all 120 of them, is an illegal structure sitting on land they have no right to even stand upon. The judge, who had looked bored throughout Thorne's presentation, was now leaning forward, his eyes wide. You could hear a pin drop. I looked at Thorne. The color had drained from his face. He was frantically whispering to his associates, pages of their pristine binders turning uselessly. They hadn't done the deepest due diligence. They were so focused on the deed, they missed the covenant that governed it. In their arrogant rush, they had built an entire neighborhood on a legal landmine. The judge cleared his throat, the sound echoing in the stunned silence. He looked from Sarah's triumphant face to Thorne's panicked one, and finally, his gaze settled on me. Based on the evidence presented, the judge said, his voice slow and deliberate, the court finds the restrictive covenant of 1961 to be valid and binding. The plaintiff's quiet title action is hereby denied. A gasp went through the courtroom, but the judge wasn't finished. He fixed Thorne with a steely gaze. Furthermore, the court is compelled to address the severity of this violation. We will now move immediately to the matter of permanent injunctions and the determination of damages. Mr. Thorne, your clients have a much bigger problem than a faulty deed. He turned back to Sarah. Counselor, what remedy does your client seek for the utter desecration of her protected property? Sarah didn't even blink. She looked the judge dead in the eye and delivered the line that would change the course of my life forever. Your Honor, she said, we seek the total and immediate demolition of every single illegal structure. The word demolition hung in the air, not as a request, but as a statement of fact. It was the silence that followed that was the most profound sound I have ever heard. In that moment, the legal battle was over. The war for the soul of the land, however, had just entered its final, unimaginable phase. The judge granted a permanent injunction, freezing all construction and sales activity for the so-called Heritage Oaks development. But that was just the start. The real battle became about the remedy. Pinnacle Development's lawyers, now in a state of sheer panic, fought desperately to avoid the unthinkable. They offered settlements that climbed into the stratosphere, numbers so large they felt fictional. They offered to carve out a 5-acre estate for me, ringed with a stone wall. They even offered to name the development Evans Grove in my family's honor. But money was no longer the point. It never really had been. This was about the principle, the legacy, the rose garden and the oak tree and the wildflower meadow. Accepting a check would have been a betrayal of everything my grandfather stood for. It would have meant that a corporation could violate anything sacred, so long as they could afford the fine. So we held firm. We demanded the land be restored to its previous state. The final judgment was a seismic event in the world of local real estate. The court ruled that Pinnacle Developments had acted with gross negligence and willful disregard for a legally binding covenant. They were ordered to bear the full cost of the demolition and land reclamation. Furthermore, they were liable for compensatory damages for the irreparable harm to a unique heirloom property, a number the court set at a value that erased every cent of profit they had ever dreamed of making, and then some. The demolition was not swift. It was a slow, methodical, and strangely solemn unraveling. The same heavy machinery that had roared to life to build this place now returned to tear it down. I watched from my porch as houses, fully framed, wired, and plumbed, were deconstructed. It wasn't a violent explosion, it was a systematic erasure. Siding was stripped away, revealing the wooden skeletons beneath. Roofs were peeled off, walls came down. For months, the neighborhood of ghosts was dismantled, truckload by truckload, until all that remained were the empty streets and the concrete foundations, which were eventually jackhammered into rubble and hauled away. The land was scarred deeply. It would take years for the grasses to return, for the earth to heal from the wounds of construction and deconstruction. But it was mine again, quietly, achingly mine. The long-term consequences rippled out far beyond my property line. Pinnacle Developments declared bankruptcy within the year. The story made national news, not as a human interest piece, but as a stark warning to developers everywhere about the critical importance of deep, thorough title searches. The lead lawyer, Mr. Thorne, left his prestigious firm. I heard he teaches real estate law now, and I can only assume my case is a central, cautionary tale in his curriculum. The County Planning Commission was overhauled, with new regulations put in place to prevent a zoning variance from ever being granted without the verified, notarized consent of every landowner involved. As for me, the victory was bittersweet. The financial damages allowed me to pay off the mortgage on the farmhouse and secure my future, but no amount of money could bring back the old oak tree. The land is healing, and I've dedicated myself to helping it, planting new saplings and reseeding the meadows. It will never be exactly as it was, but it is free, it is whole, and it is protected by a legal precedent that will now live on long after I'm gone. So, what is the takeaway from all of this? It's not just a story about beating a greedy corporation. It's a story about the quiet, forgotten documents that hold more power than any bulldozer. It's about the fact that the most powerful weapon you can have isn't always a lawyer. Sometimes it's patience. Sometimes it's a deep, stubborn love for something that can't be replaced. They had all the money and all the momentum, but I had the deed, I had the covenant, and I had nothing left to lose. I'm often asked if it was worth it, the stress, the fear, the years of my life spent in that fight. Look out at that field. Listen to that silence. It's no longer the silence of defeat, but the silence of peace, hard-won and absolute.